really laid down with regard to inclusion of the Chief Justice of India. Please remove it from
I'm
your,
not even.
your mind.
I'm not.
Was it necessary
Yes.
for a 5-judge constitution bench to write over 300 paragraphs for a 142 order?
I'll answer that.
Can it not be severed?
I'll.
Concluding part is 142. But some law has been interpreted by the constitution bench, which includes the constitution, what has to be the structure. Supreme Court, 5 judges
No,
spend so much time
I would
and
not.
then write such a
I would not like to.
painstaking, erudite judgment.
and-
But Anup Barnwal has interpreted the constitution and laid down what the law is
You may take a lot.
about the independence of the commission.
Yeah,
Right? What
I.
precludes us from borrowing the language of Anup Barnwal in writing our judgment that this is law? Answer this question.
Your Lordship.
Let us assume we accept your proposition that Anup Barnwal is 142. Right? But Anup Barnwal has interpreted the constitution and laid down what the law is
You may take a lot.
about the independence of the commission.
Yeah,
Right? What
I.
precludes us from borrowing the language of Anup Barnwal in writing our judgment that this is law?
Well, that's one
No
possible.
copyright violation.
Well, there's one
Is the
possible.
Supreme Court speaking?
Your Lordship.
Is the Supreme Court speaking? We will just simply borrow that language.
Your Lordship can do
You can't
that.
say that we are
Your Lordship can.
passing a 142
Your
order.
Lordship can do that, but then that's where I think not that I am asking the court to desist from exploring this issue. I only laying bare the contours of the debate which will necessarily be involved in it. And that question is a very important question. I'll answer that after I read Anup Barnwal.
Yes, yes.
Uh,
We are not going to say anything based on what Anup Barnwal has really laid down with regard to inclusion of the Chief Justice of India. Please remove it from
I'm
your-
not even.
your mind
I'm not even looking at
that
that.
we are on that.
No.
Chief Justice of India's inclusion will make
No, I'm not. I'm not looking at it
things
at
so
all.
much better that no one else can be considered.
No.
We are not on that at all.
In fact, I don't want to enter into a debate which will be the best method. I think in this matter,
If at all,
yes.
leave it to Parliament.
I'm not entering.
Parliament
Correct.
is enjoined under the Constitution to
Correct.
legislate. We are not to legislate. We are only to interpret the law. And if at all we are with them, we can say that yes, for XYZ reasons, we feel that 14 is violated. Only to this extent, not on the basis of Anup Barnwal.
I know.
On the basis of Anup.
I know. That's why I thought I should also place it.
If I can express my mind further, after the Constitution is the fountainhead of all legislation. Which legislation, according to you, has the next importance in the entire list of central legislations? We have thousands of legislation.
Yes.
If one were to ask you,
Yes.
after the Constitution,
Yes.
which legislation has prime of place or pride of place in the entire set of legislations?
Yes.
Which one will you put?
No. Then I will have to classify them, in the sense that you lost putting a very important question. I'll answer that. If I look at only an independent judiciary, then ultimately, if there is no independent judiciary, then we have, as S.G. Jaisinghani said, women caprice. We are not talking about a women caprice. For rule of law is best captured and comprehended. In all such circumstances, when Parliament has occupied the field by enacting an appropriate law, which in its wisdom will be relevant, the pronouncement of the Hon'ble Court will not be merely a matter of history and cannot be treated as having judicially enforceable authority. I thought a very important question for Lord's consideration. And in fact, it took me quite a time to understand.
Was it necessary?
Your Lordship.
Was it necessary
Yes.
for a 5-judge constitution bench to write over 300 paragraphs for a 142 order?
I'll answer that.
Can it not be severed?
I'll.
Concluding part is 142. But some law has been interpreted by the Constitution bench, which includes the Constitution, what has to be the structure, what is the
I
architecture.
certainly answer that question. I'm bound to answer.
You will have
I'm bound to answer it.
in
And
course of your argument, touch upon this.
It's not
because
it's not,
if it had been really 142, the Supreme Court would have said very well.
I would not. I will.
Though law has been laid down for 7 decades, you frame the law as per your wisdom, but in the interregnum, we say that this should be the structure of the commission.
No, that had troubled me.
That is the matter.
Yeah.
Why would the Supreme Court, 5 judges,
No, the
spend so much time
I would
and
not.
then write such a
I would not like to.
painstaking, erudite judgment? It's history only.
Why have you said
It's
that?
stretching a bit too far. It's only history. And
If I have not put it like that, this question would not have come to me. So I thought so much about what will be the appropriate way of communicating to the court.
Right.
Therefore, your lordship knows in the course of the discussion with the bench, we make certain propositions, not be necessarily logical to be accepted or not. It's for the purpose of having a very high level of conversation and engaging our minds. That's why I thought, let me put it like that. I know that you can't simply wish it away.
right.
I'm not saying wish it away. But then you can't wish it away. How do you give a place to it in the jurisprudence of a country? That's where I found myself a lot of troubling questions. Not that, and therefore I said when I argued this matter before Hon'ble, we had encountered certain factual questions were put to me, we produced how the appointments are made, and then we also looked into all possible global alternatives and things like that. The court went into all that exercise. But if Parliament, for instance, after having the Constituent Assembly, with all that intense debates, and the change brought in Article 324, after Saxena suggested something, it was subject to law made by Parliament. Suppose that subject to law made by Parliament was not there. And Constituent Assembly had spent a lot of time saying that we need an independent election commission, and left it entirely to the President. Then what would have happened to the constitutional scheme? Therefore, when they thoughtfully said, in a future time, when a future Parliament will take stock of a given situation and finds it necessary that the authority which has been entrusted to a high functionary like President has not yielded the requisite result. We need to go farther. Therefore, a future Parliament taking stock of any evolving situation will have the better wisdom to find out what can be the better law.
Indicated a mechanism
Yes.
rather than enacting one.
No, and that's where that's where
It
I think there is some
mechanism.
issue there. One could have fallen into that. One could have fallen into it. I said even before Hon'ble, we discussed what possible alternatives could have been there. Whether this particular committee's report or the Law Commission report or just Venkatacharya Commission report. For instance, Venkatacharya did not suggest what the Hon'ble suggested. Therefore, so many suggestions before the court. Can I ask this question then? Can council or parties give a menu for a choice before the court and say, please pick up any one of them?
No, not at all.
But such menu was given to the court. We are talking about institutions which have been conceived under the Constitution, each one of them occupying their distinct space and spheres. And they get connected in a way so that each and every department of governance, economic, social, political, each one of them, I think, deserve their special importance. So if I had to answer this question only saying this institution, this law is the foremost, perhaps I'd be missing the connections between the democratic governance and our constitution.
If I say election laws,
I'm coming to
am I wrong?
I'm coming to that.
You have just hit the bull. You have taken the bull by the horn. You say democracy.
I'm coming to that.
Without democracy, you have nothing.
Of course we are. But then I was wondering, why did I say democracy is important? But even in the context of democracy, you may have a free and fair election. But the social, economic and political governance part of it will be more and more, I think, more expansively governed by our institutions of justice. You may have a small problems here in free and fair election. We manage them with a little dent here and there. But if we don't have an independent institution of judiciary, we have fundamental problems. Today, I'll tell you what's happening in Nepal. Yesterday, I received some very intensive calls from 3 judges. It's unimaginable what's happening. Either they're asked to resign or face impeachment. So, fortunately for our country, None of those things which happen in our neighboring countries have ever invaded our democratic process. Fortunately for these two institutions, the free and fair election and the institution of justice.